Pregnancy Discrimination by Leslie Wilfred, Employee Law, April the 12th of 2016. The Pregnancy Discrimination Act is an amendment to Title VII of the Civil Rights Act of 1964. Discrimination on the basis of pregnancy, childbirth, or related medical conditions constitutes unlawful sex discrimination under Title VII. Peggy Young versus United Parcel Services. Peggy Young was employed by the UPS as a delivery driver. In 2006, she requested a leave of absence to undergo in vitro fertilization. After going through the procedure, she found it to be successful. She was indeed pregnant. As she underwent her prenatal care, her medical providers advised her not to lift anything over 20 pounds while working. According to UPS, their requirements for their employees are that they be able to lift over 75 pounds. And due to her inability to fulfill her duties and her use of all of her medical leave, UPS forced her to take an extended leave without pay. During this time, she not only lost her insurance coverage, but also gave birth in April of 2007, after which she did resume working for UPS. Young then sued UPS, claiming that she was a victim of gender and disability discrimination. UPS argued that she could not show that their decision was based on her pregnancy or that she was treated any different than any other coworker. They also argued that they had no obligation to offer her any accommodations under the Disability Act because pregnancy is not a disability, and at that time, the courts dismissed Young's claim. Justice Samuel A. Alito, Jr. said to determine whether the conduct was discriminatory, he argued that the treatment of pregnant employees should be compared to the treatment of non-pregnant employees in similar jobs with similar abilities and inabilities to work. Years later, in the Supreme Court, Justice Stephen Breyer, Justice Roberts, Ruth Ginsburg, Sonia Sotomayor, Elena Kagan, and Samuel Alito heard Peggy Young's case. They then found that Peggy Young indeed had the right to sue UPS for pregnancy discrimination, after they refused to give her a less demanding shift when a medical professional ordered her not to lift any heavy objects while pregnant. Ooh. The case has lasted from 2008 until 2013, when it was finally decided upon. Young lost 2 prior rulings in this case. UPS changed its policy for pregnant workers, now offering light duty as needed. The Supreme Court did not issue a rigid rule that will dictate when employers must make accommodations for pregnant women. And in 2013, there were 5,342 pregnancy discrimination acts filed with the EEOC. There are many more cases, some such as Jamie Cole, who took out an equal employment opportunity complaint against her employer in October of 2014. Then in November of 2014, a mother was awarded $185 million in pregnancy and gender discrimination case against AutoZone. But back in December of 1992, a woman was awarded $349,000 in pregnancy discrimination suits. One in two mothers reported experiencing discrimination in the workplace at some point during pregnancy, parental leave, or on return to work.